Hello and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. Malaysia is facing an unprecedented moment in our judiciary. The two highest posts in the judiciary will become vacant within days of each other. And as at the time of this recording, there is still no formal announcement of succession. At the same time, the Judicial Appointments Commission is reportedly under strain with questions raised over allegations of interference. Now, what's at stake here goes beyond the bench. It's about the legitimacy of the system itself. And joining us to discuss this further is Steven Thiru, President of the Commonwealth Lawyers Association. Steven, thank you so much for being on the show with me today. We are in quite an extraordinary moment. As I mentioned, the two top judicial posts are set to fall vacant in a matter of days. No formal announcement of succession as the time of our conversation. Can I ask you how unusual this is in Malaysia's legal history? And are there concerns that might arise from the fact that there is going to be a vacuum at the top of the judiciary?
Thanks, Melissa, and thank you very much for the invitation to speak on this very troubling scenario that we have in front of us today. Unprecedented, if I may say so myself. It is not the norm. It is quite usual for us to have a seamless transition, whether it's by way of an extension or an appointment to the top officers, the top four officers of the judiciary. We have a Judicial Appointments Commission. The Judicial Appointments Commission would have made its recommendations to the Prime Minister, a decision that it would have communicated to the Prime Minister. And the Prime Minister is then obliged to communicate that and make his recommendations to the Council of Rulers for appointment by the King. So we have a process, and that process is intended for us not to have the vacuum or a sense of an indefinite vacancy in these two critical positions. The position of the Chief Justice of the Federal Court and the President of the Court of Appeal are apex positions, and they are responsible for the two highest courts of the land, the Federal Court and the Court of Appeal. They exercise both judicial and administrative functions. And in that sense, you can understand how critical their role is. It is actually quite unthinkable that we have this situation where the positions will be left vacant as we speak upon the retirement of CJ Tun Tengku Maimun and PCA Tan Sri Abang Iskandar. And the other thing is, we also must bear in mind, the CJ and the PCA are the two most senior mandatory members of the Judicial Appointments Commission. And without them, the functions of the JAC will also be hampered. In short, the vacuum that we have leaves the judiciary in a sense of being leaderless and rudderless, and that is quite unacceptable.
Okay. Steven, you recently wrote an article and in that you talked about the separation of power and how it's essential to judiciary legitimacy. Can we explore that? What do we need to do now to safeguard against the perception or even the reality of the judiciary being compromised?
Now, the system of separation of powers is meant to prevent any form of overreach by either the executive or the legislature into what is the domain and the province of the judiciary. The judiciary is an equal partner of the three arms of government, executive, legislature, and judiciary, and there should be no interference in the exercise of the usual functions by the judiciary, by the executive and legislature. The judiciary is unique because the judges take the oath to defend the Constitution, and they exercise judicial power in accordance with the Constitution and the law. They are not answerable to the executive or the legislature. And the judiciary is, again, in a unique position because it plays a role of a check and balance on the exercise of executive and legislative powers. And by that, what I mean is, in deciding cases, it curbs the abuse of these powers. Now, the non-extension of the CJ and the PCA, and indeed the inordinate delay that we are seeing now in appointing even their successors, has given a perception that there is executive interference with the appointment process. That's the public perception. And that the executive interference here is beyond the role that the executive has under the Constitution and the JSC Act. In other words, it is a form of executive overreach. It is very difficult to dispel that perception, because that perception also goes to a further perception, if you like, that the judiciary is being, in a sense, punished, or there's retribution, because it has not decided cases in a particular way which favors or which would find favor with the powers that be. That's again a perception. And that's why we have come to this unprecedented position. Now, if you look at, and it is difficult to dispel this perception, because you've had stellar judges like Tun Tengku Maimun and PCA Tan Sri Abang Iskandar, who have both distinguished themselves as judges of eminence and who have gained acclaim throughout the common law world. They are, in short, world class, and we should be proud of them. And indeed, we are surprised and, in fact, very much upset that they have been so poorly treated that we should now maybe think of hanging our heads in shame that we would do this to our best.
Right.
So perhaps to really answer your question, the first step, given this experience that we've just had, or the experience that we're going through, we should look and reconsider the role of the executive in the appointment process. Should it be a system where the Judicial Appointments Commission makes the proper recommendation to the Prime Minister and the executive at large, and much deference is given to that recommendation because it comes from a group of people that Parliament have put in place to vet and decide who are the appropriate persons for these appointments. And that deference is only set aside if there are credible, compelling reasons as to why those recommendations should not go forward. Otherwise, it should follow through. Perhaps we should look at that. We should look at reforming that appointment process and to not remove completely, but to reduce the role that the executive has at the moment in the appointment process.
Could I explore what you just said about perceptions? Now, in that article that I cited earlier that you wrote, you, if I may quote you, said an independent and fearless judiciary means, and an independent and fearless bar are two twin pillars of the law. Can you talk to me a little bit about what role the legal profession has in terms of responsibly and credibly speaking out in this climate where it could be, where critique could be seen as carrying consequences?
Well, the bar, whether as an institution or as individual lawyers, must always promote, preserve, and defend the independence of the judiciary. We cannot and must not shy away from that role, because that's in essence upholding the rule of law. And the bar, and certainly the Malaysian bar, speaks up openly and courageously, without fear or favor, and without regard to even our own interests. We speak up and advocate for judicial reform, or our concerns for the appointment on the bench, and all of that is done in good faith. It is not about politicizing the appointment process. No, it is not about lobbying for positions. It's about the independence of the judiciary being preserved, protected, and not interfered with in any sense. So I think there's a misconception that when the bar speaks, that the bar is seeking to speak for any one person or persons. The bar speaks for the institution. It speaks for the institution being an institution that remains independent, that remains impartial, that remains in a position where it can discharge the role that it is obliged to discharge under the Constitution. That's what the bar speaks about. And when there is any shortcoming or any failure in that aspect, we cannot keep quiet. We will speak up.
All right. Steven, you mentioned just now, you described the Chief Justice as stellar, as world-class. Could I ask you how you would describe or characterize her legacy? Chief Justice Tengku Maimun, in the way that she led the judiciary, how would you describe it to us outside of the legal profession?
Chief Justice Tun Tengku Maimun has been in office since 2019. What we have seen is that she has raised the profile of the Malaysian judiciary, raised the profile of the Malaysian judiciary as an independent, competent, and a world-class judiciary. The federal court that she has led has handed down many landmark decisions that have shaped the jurisprudence, the law of the land. As a judge, she's a judge who we all consider to be one with a deep conviction for what is justice in any given case. And many of my colleagues in the bar will agree that she has discharged her duties with competence, with a skill, and with a degree a degree that is so acceptable in the way in which justice is discharged in this country, that she has quite rightly received the public accolades and recognition, not only in Malaysia, but throughout the world. Now, if I may just stray a bit into my role as the president of the Commonwealth Lawyers Association, we've had the privilege of having had her as a speaker, a keynote speaker, in 2 successive conferences, in Goa in 2023 and recently in Malta. And she was in a panel of other eminent judges from the Commonwealth, senior and experienced judges. And in both sessions, she spoke about the importance of the independence of the judiciary. And in both sessions, she spoke in terms in which it carried wide acceptance throughout the Commonwealth. And indeed, I recall in Goa, she even received a standing ovation. If you just permit me, this is what she said in the Malta conference recently in April 2025. She said this, and I quote, "Justice is beyond the political process. An independent judiciary exists for the primary purpose of doing justice, unimpeded by any external or internal factors that do not concern the law and the facts. The judiciary is motivated only by the need to uphold the rule of law," unquote.
I have goosebumps. Stephen, thank you so much for sharing that with us. I appreciate your time. Steven Thiru, President of the Commonwealth Lawyers Association. And we're going to take a quick break here and consider this. We'll be back with more. Stay tuned. Hi, welcome back to Consider This. I'm Melisa Idris. Let's continue our discussion about the prospect of an unprecedented vacuum in the leadership of the judiciary. This as 2 of the most senior judges in Malaysia, the Chief Justice and the President of the Court of Appeal, both are stepping down within days of each other. And as at the time of this recording, there has still yet to be no formal indication of who will succeed them. So joining me on the show now to discuss this further is constitutional lawyer Datuk Malik Imtiaz Sarwar. Datuk Imtiaz, thank you so much for being on the show with me today. We're looking at vacancies of the top 2 judicial posts. No official succession plan as yet. What are your concerns about the fact that we still have not heard about who might be succeeding this post? Are there concerns that could arise from such a leadership vacuum?
Yeah, so, well, I think it sends a very troubling message to the public. And, the judiciary as an institution is only as effective as public confidence in that institution. So people have to believe that the decisions of the court are being made in a way that the law requires and so on and so forth. And for that reason, the courts have always been very vigilant about public confidence. So you'd have read their decisions on contempt hearings where the court keeps on stressing that nothing can be allowed to bring the court into disrepute or into some situation where people might start to wonder about the quality of justice that's being meted out. So when there's a leadership vacuum, the obvious question is why? And one would have thought that the succession issues would have been dealt with well in advance, that approach would have allowed for transitioning within the judiciary. And I think that transition process is very, very important because you've got an outgoing chief, and after retirement, and I'm assuming she's not extended, after she retires, Tengku Maimun will no longer be a judge and will no longer therefore be in a position to be able to sort of offer guidance and necessary transition advice. You know, in the usual course, in any situation, when you have, like, say, a CEO leaving a company, you would have a discussion as far as possible between that CEO and the incoming CEO. And so that sort of discussion is not going to happen. Valuable experience, therefore, may not be shared. So that's one big aspect. I mean, the other aspect is that as I said earlier, the question also is, why is it that there has been no successors identified any earlier? And again, the impression, and I'm going back to impression, and that in this case is driven by the fact that, you know, we don't have much information being shared either by the government, and the JAC is not in a position to share any information. So we don't know what exactly is going on. And when there is that kind of space, people tend to fill it with speculation, conjecture, some of which may not be entirely positive. And that then boomerangs against the institution as well as the judges. So at the end of this, if certain judges are appointed as successors, the situation may be such that questions will arise. Why were these people appointed as opposed to X? And that's not their fault necessarily, but because the way in which the process has been handled, and given that vacuum and the speculation, etc., it may come to that. And that's not necessarily conducive either.
Right. Could I ask you about that? What are the risks, both institutionally and maybe even in terms of morale, if any individual is seen to leapfrog more senior judges in the hierarchy to the top two positions? I mean, I'm just wondering how that might not just impact perceptions of meritocracy, but also perceptions, as you said, of integrity, institutional integrity.
Well, I think you've said it. Essentially, if there is a leapfrog, unless there's obvious reason for that leapfrog, and I mean, to be fair, I'm sure the judges will appreciate the right candidate going up, even if it means leapfrog. And seniority doesn't in itself define that process, although it is relevant. If there is leapfrogging and there's no obvious justification for it, questions will be asked internally as well as externally. So internally, then you've mentioned morale. I think that's a very big question here. You know, we've had a very good run from 2018 with Tun Melanjum first, who set the foundation for what many are calling the judicial reform. And then with Tengku Maimun coming in and entrenching certain principles that the Melanjum court had put into play, it's only done, I think, very good things for the judiciary and the reputation of this country. And I must stress here that, you know, in as much as the chief, Tengku Maimun, is the chief, decisions of the court are not hers alone. So that I've been hearing a tendency to say, well, that's a Tengku Maimun decision. Well, you know, like some of these so-called controversial Islamic conflicts issues, the decisions have been decisions of the court. In some instances, as many as 9 judges have agreed on the issues. So you can't say that's a Tengku Maimun decision. That's a federal court decision where the court unanimously decided, or by an overwhelming majority had decided X or Y. So to be fair to Tengku Maimun, then one should actually be asking who else was on that panel. And in these Islamic cases, you've had a spectrum of judges on the federal court, some of whom we would call conservative judges, who agreed with the approach taken on the constitutional points. So the public confidence question is, I think, extremely important. And the subjectivity that is now being introduced into the process, perhaps unwittingly, is not at all conducive to any notion of the rule of law. It does not matter that a person sits as a judge at whatever level if people aren't confident in the abilities of that person to do the right thing. And this is not meant to denigrate any particular person. That is the nature of public confidence. Yeah. So the government, and in particular the Prime Minister, you'll remember the notorious VK Lingam affair. And what resulted from that was the Judicial Appointments Commission Act and the establishment of a formal appointments process that would take away from the somewhat subjective way in which things were being done before, a process which is open to some element of manipulation. So, after all of that, if you have a situation where this sort of subjectivity is introduced, then it could be said that perhaps the whole system is not working as it should.
Well, you alluded to the fact, or you touched on the fact that the JAC, the Judicial Appointments Commission, is opaque by its nature, right? We don't know what happens behind it. But recently, there's been some reports or speculation, rumors, if I may use that there were concerns that the JAC had with a member of the bench about undue influence, about possible interference in judicial affairs. Now, I know we can't speak to specifics, but what do you think can be done now in this moment where there is an institutional transition, where there is maybe, I would even call a crisis of public confidence? What do we need to do to restore or maybe safeguard what confidence is left of the judiciary, in the judiciary?
So I think there are 2 points there. One is, I think on the immediate situation, I think the government, and in particular the Prime Minister, owes it to Malaysians to explain what's going on. And I say this because the JAC Act itself charges the PM specifically with defending judicial independence. And judicial independence necessarily means public confidence. So I think the Prime Minister, therefore, owes an explanation to Malaysians to sort of calm the waters, as it were, on what's happening, as to why it is that some judges got extensions and others didn't. The speculation is that that may have something to do with the JAC composition, one wonders. And other things. For example, why it is that it's taken so long to identify successors. Why is it that there was no transition process allowed for? These are important questions moving forward if the government wants to project to the world at large that Malaysia is a system based on the rule of law. Instead, however, with all due respect, the Prime Minister has sort of focused on deflecting these questions by saying that people are attempting to politicize the process and so on. I mean, respectfully, I don't think that's the most constructive way to deal with it. Whatever the reasons, and there may be good reasons for it, I don't think we should be left to wonder. And to be fair to the judges themselves, as well as the outgoing judges, this explanation is critical. It's fundamental to the integrity of the system.
Right. Well, speaking about the outgoing judges, can we talk a little bit about the Chief Justice, Tengku Maimun? She has been described as such a powerhouse, and I'm just curious to know what you think. What is your impression of her? How would you describe her legacy, her imprint, the imprint that her leadership has left on the institution?
Yeah, so I was admitted to bar in 94. And I can say in all that period of time, in my experience with the court, she's the best Chief Justice we've ever had. And I don't think I'm overstating it by saying that. And it's not necessarily because all her decisions were absolutely correct and not open to some comment or constructive criticism, but on certain fundamental things, she's hit all the right notes in a way that I think we had all been yearning for as Malaysians. Because what is, I think, the legacy she leaves behind is that the federal court and the other superior courts of this country are independent. Judicial power is sacrosanct. It is not an agent or tool of the executive, and it stands as the bulwark of freedoms and civil liberties between the state and the citizen. And what Tengku Maimun has done with the court, and again, I must stress the decisions are not hers alone, but she has, on these very, very difficult issues, united the court, or an overwhelming number of the judges of the court, into crafting and refining a constitutional basis that is unique to Malaysia, where the rule of law, judicial review, and the doctrine of check and balance is concerned. And for that, I don't know how it is that Malaysia could actually repay her for what she's done. Of course, if you asked her, she'd say there's nothing to repay, because that was her duty, and that's what makes her, I think, exceptional. And I think what's made her exceptional is also the fact that, apart from being a woman, which I think was great, and I think we needed a woman Chief Justice for various reasons, apart from that, she transcended cultural and racial matters in a way that, again, as I say, was inspiring, because during her time, the federal court, in an overwhelming number of decisions, has looked at the law in an agnostic way. This is not personal religion, but the law itself, the constitution itself, is not colored by matters of these things. You look at it as the supreme law, construe it in the way that it was meant to, and fundamentally allow the law to lead you to outcomes, as opposed to shaping the law to suit outcomes. And I think that is something that she has left many a young lawyer inspired by. And I'm hoping that, for this generation of young lawyers, this serves as a yardstick by which future efforts can be measured. And if the court were to continue on the trajectory that she set, with Tun Malanjum, then I think we can see the possibility of a lot more things happening. But again, having said that, the court has also been very careful in not transcending into executive powers. And that idea of the demarcation between the three major organs of state is very, very clear. Supremacy of the Constitution impacts the judiciary in as much as it does the executive and the legislative branches. I suppose to some extent people might be unhappy because it's sort of upset an incumbent mindset, but we had been we were in the process of being liberated from that mindset, from as early as 2016 when Tan Sri Zainun, with the other members of the court then, developed this idea of judicial independence and looked at the 1988 amendment, which we all accept now is unconstitutional. So yeah, I'm sorry, I rambled on, but
No, it was a lovely way to encapsulate her legacy.
I mean, she's a hero. She's my hero. I'll say that much. And honestly, I never thought I'd see the day when the federal court would take certain things in hand and deal with it as it should.
I'm sure she's a hero to many of us Malaysians. Thank you so much for sharing your insights with us. I appreciate your time. That was constitutional lawyer Datuk Malik Imtiaz Sarwar there, wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching, and good night.